interactive agencies, marketing, PR firms. Really, it's a wide array of types of industries that our clients represent. Since I don't know what specialty anyone of you might be going into, I'll just cover the basics of startup law, if there is such a thing. I think there is, actually. What you might want to know when organizing your company to make sure your brand is protected, your customers pay on time, etc. The first thing you would do is form a company. Contrary to popular belief, it doesn't really help you write off taxes. What it really does is cuts off your personal liability for any sort of exposure you may have to your landlord, to your staff, to your customers. So that if you don't deliver on time and your client decides to sue you, or if you don't, let's say, I don't know, pay your rent on time, and your landlord decides to go after you, they could only reach the funds of the company you formed, and not your personal assets. That's the most important aspect of incorporating. Either a corporation or a limited liability company, an LLC, accomplishes this goal. It creates this legal shield between yourself as a person and your creditors. So you have that choice. The differences between forming a corporation and an LLC are kind of subtle. You can be what's known as an S corp and pay taxes only once on the personal level, not on the company level. You can be an LLC and pay taxes only once on the personal level, not on the corporate level. Those are known as flow-through entities. If you have a foreign partner, or you don't have a green card or U.S. passport yourself, you are not eligible to be an S corp, so the choice is made simple. You have to be an LLC. If you might take venture capital or have a partner that is an entity as opposed to an individual, the choice is also made for you. You have to be an LLC. S corps may not have shareholders that are entities. They have to be individuals. So if you have institutional investors on the horizon or foreign partners who might work with you, you have to be an LLC. Short of that, you really could go either way, and it's really best to speak with your accountant to see what's best in your particular situation. The next thing you need to worry about is the name of your business. And it is a good idea to do a trademark search, just a regular Google search for the name you're considering before you start using it on business cards, in your letterhead, in your contracts, anywhere. Because to reverse that, to change the name, doesn't cost a lot in terms of filing with the state, but it does cost a lot in terms of your branding. You don't want to do it twice. So consult a lawyer, or at least go to uspto.gov, G-O-V, United States Patent and Trademark Office.gov. Select trademarks, select search, put in the name you're considering, and see if there are any hits. Those are trademarks that are registered, and you definitely have to stay away from that if any of them are in your field. Trademarks are field specific, so if you're starting a restaurant and there is a clothing line under the same name, no problem. But if you're starting a retail store and somebody is making sneakers with that name, it might be a problem. So it's industry or what's known as class-specific trademark classes. have a partner, an investor, there may be two of you going into business together. Your next priority should be a partnership or operating agreement. If you don't have that, the risk is that your partner might leave with 50% of your company. And you don't have any mechanism to claim any of the capital. So you're stuck with having to run this business through that entity because you can't move it out. That will be fraud or theft. You're stuck with continuing to run your business, paying out half of your profits to the partner who's not doing much. To avoid that, you need an operating agreement that provides for a vesting schedule for both of you, it's mutual. If they leave after only 6 months, let's say, they've only vested that much in terms of percentage. That's obviously crucial. There are many stories when people are stuck and they're forced to either continue to share their wealth with somebody who has not contributed, or move to a totally different industry altogether. There are other terms that go into an operating agreement, but that's definitely something you want to consult a lawyer to put in place. If you have staff or freelancers who work for you, it's necessary to have them sign employment or consulting agreements, also known as work for hire agreements. In the case of employees, without such an agreement, that's from employees, take away the concept behind your business, start a competitive business. To protect yourself against that, you need an employment template that the employees sign. In the case of freelancers, in addition to all of those concerns, which are basically poaching, competition, confidentiality, in addition to those, you have the issue of intellectual property ownership. So if you have a freelance web designer that you engaged, or a person who drew your logo, or might have contributed to the formula of your perfume, anything at all. Unless you have them sign a work for hire agreement, they walk away owning what they create by default. And all you paid for is one copy of that. And they can go off and replicate it for anybody else. Definitely not something you want. So employment agreements for staff, work for hire agreements for freelancers. Then you have your customers and clients. It is important to have agreements with them too, to make sure they pay on time, to make sure they don't poach your employees, and to make sure the liability of your business to those clients is limited. Because without it, if you don't deliver something on time, the client's business suffers. Their whole marketing strategy might collapse or get delayed because of something they claim you did. They can go after you for their entire marketing budget. It's like a domino effect. You didn't deliver something on time, they couldn't work with another vendor because of it. You are going to be paying for all of the replacement costs that the client incurs unless you have a properly drafted